Hello everyone, I'm Viv Coles. I'm a senior finance caseworker based in the Cardiff office. I've worked for the LAA for around 13 years now. I started in our admin support team when everything was paper-based, and then I shortly moved on to the civil billing team where I've been since. In the team, I process most types of bills. I also do appeals and billing inquiries. Okay, so before we look at some specific aspects of billing claims that fall within the fixed fee scheme, we just wanted to give a sort of overview of the scheme itself, taking into account some of you may be quite new to billing legal aid costs. Okay, so slide 6, there are two fixed fee schemes. There's the Care Proceedings Graduated Fee Scheme, known as CPGFS, and the Private Family Law Remuneration Scheme, PFLRS. So for the care proceedings, this was introduced on the 1st of October 2007, and only proceedings under Section 31 of the Children's Act 1989 are covered under this scheme. So that's care and supervision under Section 31. It doesn't cover any other public law children matters, so it doesn't cover things like emergency protection orders, adoption orders, and the like. Up until the 9th of May 2011, advocacy still fell within hourly rates for solicitors and counsel. A counsel actually claimed under the Family Graduated Fee Scheme. There was no fixed fee for private law proceedings during this time. It was only for care proceedings. And then from the 9th of May 2011, advocacy then fell under the newly introduced Family Advocacy Scheme, which we all call or refer to as FAS. Okay, moving on to slide 7, calculating the applicable care fixed fee. So this is based on a number of factors. So it's based on the party that's been represented. So that would be the parent or the children or joint party. It's also based on the provider's office location. So not where the court is based, but the provider's actual office. And also at what level the proceedings concluded, so whether it was High Court or the lower court, so at district judge, circuit judge or lay bench level, as to the High Court fee is slightly higher. The escape fee threshold for care proceedings is 2 times the applicable fixed fee. Guidance on the scheme can be found in section 4 of the electronic handbook, and the link is actually in the slides. Okay, so one thing we thought would be useful, and that's in the top tips on that slide. So where joint party status is refused or the client withdraws their application to join as a party, the care scheme and FAS do not apply and they should be billed at hourly rates. CCMS doesn't actually generate rates that apply to the proceedings. So in order to submit hourly rate claims, providers and counsels should tick yes to the question asking if you were instructed for less than 24 hours, and that will then generate the hourly rates you need. Okay, moving on to slide 8. So this is the Private Family Law Remuneration Scheme, so PFLRS. So this was introduced in February 2012. And it generally covers all private law family cases, but there are some proceedings excluded from the scheme, and there's a link in the slides to the relevant section of the electronic handbook, and that's 5.1 of the handbook. For advocacy, private law standard fees under the FAS scheme were introduced in May 2011. Okay, moving on to slide 9. So calculating the applicable private law fee. So it's slightly different from the care fixed fee scheme. So the fee is determined on the specific type or act the proceedings fall under. So that's whether they are Children Act proceedings, finance or domestic abuse matters. Again, it would be at what level the proceedings concluded, so High Court or district judge, circuit judge or lay bench level. in private law, the provider office is the key to which fee you can have for the enhanced London rate. So you have to, the office has to be in a London borough, and the fee is slightly higher for the London fixed fee. And also in Children Matters, the level of representation attracts different fixed fees. So there is a fee for family help hire, level 3, and a different fee for full representation, level 4. And the two fees together should be claimed where there is cover for both on the certificate, and you've undertaken work at that level. Okay, whereas the escape fee threshold for care is ×2, for the private law scheme, it's 3 times the applicable fixed fee. And for both schemes, you can use the rates calculator, and the link to the rates calculator is in the slides, so you can use that to check the correct fee. Okay, another top tip. So in private law proceedings, regardless of the fact the client may be the parent in the proceedings, if they're under the age of 18, when the certificate is granted, they are considered to be a child. Even though they are the parent, they're still a child. And so this is considered to be a separate representation of a child, which should be remunerated at hourly rates only. And it's always worth checking that before you bill your costs.
Good afternoon, everyone. My name's Simon James. I'm a senior finance caseworker based in our Liverpool office. I've been with the Legal Aid Agency now for over 10 years, all of which has been on civil billing, processing various types of bills and complex casework. So we're now going to cover the evidential requirements for the Family Advocacy Scheme, or FAS. So this starts at slide 7 on the webinar presentation. It's worth mentioning before I start that missing FAS evidence is the 8th top reason for rejection of claims. So you'll more than likely be aware, I'm pleased to hear, that court orders have now replaced the advocate's attendance form as a standard evidence for FAS hearings. And court orders are required for all hearings and not just those that are heard remotely. So court orders should always contain a paragraph with the following information. So this should include the start time of the hearing, additionally, any court-ordered pre-hearing discussion time, the end time of the hearing, which should also include any time after the actual advocacy is completed to draft and agree or the order, any lunch breaks or other adjournments that would not be used to calculate the hearing fee should also be detailed there. Any overnight adjournments in interim hearings should be clear on the court order where the interim hearing is heard over 2 or more days. It would be usual to have each day detailed with start times, finish times, and lunch breaks or other adjournments so that these can be calculated for the correct fee. If there's a bundle being claimed, this should be detailed with the number of pages and/or the relevant size bundle. And there should always be confirmation of any bolts-on and which party that applies to. If any of that information is missing, that will be a reason for rejection of your claim. Our top tip here is to submit the corresponding attendance note with the court order if any of that information is missing, as we can accept the attendance note as evidence. The webinar slide also includes a link to an updated Ways of Working FAS document, which provides further information on FAS evidential requirements. So moving on to slide 12 now, and how to calculate the applicable FAS fee, which is usually calculated in one of 2 ways. The first are interim hearings, which are calculated based on the duration of the hearing. So a hearing unit 1 can be claimed for hearings lasting between 1 to 60 minutes, a hearing unit 2 between 61 and 150 minutes, and thereafter multiples of hearing unit 2s depending on their duration. So the hearing is generally calculated from the time it's listed to start, which includes any pre-hearing discussions directed by the court, to the time the hearing concludes, but disregarding any lunch break or overnight adjournment. Where a court directs a party to adjourn for further discussions at court, then that time will be included in the calculation of the interim hearing fee. Where there have been overnight adjournments in interim hearings, then the total time for each day is added together and calculated then for the overall hearing time. There are different fees paid for interim hearings, obviously depending on the category of the case and the level of judge before which the hearing takes place. The fee covers all incidental and preparation work, such as drafting of skeleton arguments and orders, travel time, say for exceptional travel, and waiting at court, as well as the advocacy within the hearing itself. So the other type of hearing is the final hearing. So a daily fee is payable for these. This is payable for each day of the final hearing, excluding any day set down solely for the court to hand down judgment when no advocacy is expected. As a daily rate is applicable for final hearings, then neither advocates' meetings nor conference fees can be claimed on the same day. In the first instance, we would reject a claim for FAS to be amended as it's a fixed fee payment only. And only then, if we cannot reach agreement on the fee due, will we exercise our rights to assess the FAS fee. And you can find more information on interim and final hearings in the Cost Assessment Guidance 2018, sections 14.2 to 14.14. Our top tip here would be to use the Civil Claims Rates Calculator just to make sure that you're claiming the correct fee. And a link to this is on slide 7 of the webinar presentation. Moving on to slide 13. Only one fee per hearing may be claimed under the Family Advocacy Scheme. So if there are separate matters dealt with by the court, whether they be listed together or consecutively, this would be treated as one hearing under FAS. And 7.125 of the 2018 Standard Civil Contract provides more details on this. 15.2 to 15.21 Appendix 2 of the Cost Assessment Guidance 2018 confirms that in the situation where multiple clients are represented by one advocate and the applications are dealt with together by the court, then again only one fee is applicable. Our top tip shown on the slide is that this guidance applies to all activities under FAS, which includes advocates' meetings, conferences, and bundle fees. So slide 14 looks at hearings over multiple days. So where an interim hearing runs over more than one day, to calculate the fee, you would look at the cumulative duration of the hearing, less any adjournments for lunch or overnight adjournments. Note that this can also apply to non-consecutive hearing days, should the court consider both days to be part of the same hearing. And 14.6 Appendix 2 of the Cost Assessment Guidance 2018 does give more detail on that. And as a top tip, we would ask that you clarify the position if the orders don't make that clear. To claim multi-day interim hearings on CCMS, you can add these as a single line, as CCMS permits claims of up to 15 hours. But in the rare event that the total hearing duration exceeds 15 hours, another line can be added on CCMS for the hearing unit still to be claimed. And again, would encourage you to use the FAS multi-day unit calculator tab of the Civil Claims Rates Calculator just to ensure that you're claiming the correct rate. So slide 15 now. So a common reason for the rejection of claims is that a final hearing has been claimed when the final hearing fee isn't applicable. So 7.127 of the 2018 Standard Civil Contract confirms that a final hearing fee is payable where the hearing was listed as a contested final hearing and was effective as such. And although we don't mandate that you upload the order which listed the final hearing, providing this with your claim can help caseworkers to confirm that the right fee has been claimed. A final hearing fee is applicable where a certificate covers more than one aspect. So, for example, children, finance and domestic abuse. And a hearing is listed as a contested final hearing for one aspect, but acts as an interim hearing for other aspects. And you can find more information on this again at 7.127 of the 2018 Standard Civil Contract. 6.4 of the Civil Finance Electronic Handbook states that an interim hearing fee will be applicable should a hearing listed as a final hearing be adjourned or postponed before the substantive issues are considered. Slide 16. So this looks at the kinds of hearings which can be claimed as a final hearing. So in private law and public law matters, a finding of fact hearing can be claimed as a final hearing if the hearing was effective. And there are a couple of links to the relevant guidance on the slide regarding that. As per 7.128A 2018 Standard Civil Contract, an issues resolution hearing can be claimed as a final hearing in public law proceedings should the hearing conclude matters and doesn't progress any further. One scenario that we do see crop up from time to time is when matters concern the joint representation of children. So the issues resolution hearing would be paid at interim rates if the court only makes a final determination in respect of one of the children and further hearings take place for the other children. Note as well that directions hearings and dispute resolution appointments in private law children matters or a case management hearing that concludes proceedings isn't a final hearing and must be claimed at interim rates.
Okay, so our next topic in slide 17 is billing more than one aspect. And we thought it would be really useful to cover this as proceedings falling within the fixed fee scheme, particularly private law family. It's often the case that there will be more than one aspect, with non-molestation and child arrangement order proceedings being one of the most common scenarios. So we do see that an awful lot. So moving on to slide 18, where you have more than one aspect on a certificate, both fall within the fixed fee scheme. They can be billed separately or together, and that's the case where they would both be fixed fee bills, or whether your costs escape the fixed fee, or indeed a combination of the both. What's really important when you're working out whether or not your profit costs escape the fixed fee, when you're billing more than one aspect, is that you do your calculations separately for each aspect. So basically you can't combine the two fixed fees and the two sets of profit costs. And the table in the next slide, and that's slide 19, hopefully illustrates what I mean by that. So you can see in the table that potentially, and it does just depend on what the profit costs are for each, if you added the two fixed fees together, multiplied it by the private law multiplier of times 3, and then base the total profit costs on that, then all your costs would escape the fixed fee. But the correct approach is to calculate them separately. And you can see here that in this case, whilst the non-molestation profit costs escape the non-molestation fixed fee, on the children aspect on its own, it doesn't. And also just a reminder really on any fixed fee bills, the escape threshold should be calculated on the base profit cost. So that's excluding enhancement and excluding the cost of bill preparation. So bill preparation be the cost of drafting your bill and checking and signing. Neither of those, enhancement or bill preparation, should be included in the calculation. And just to explain the top tip in slide 18, it's not really specifically to do with billing more than one aspect, but we just thought it was really worth pointing out that if you're covered for level 3, so that was family help hire, and level 4 final hearing cover, under the private law fixed fee scheme, if you're not claiming legal level 4, please can you just provide an explanation why not? That's where your narrative is useful. So otherwise we may have to reject the bill on the basis you've made a mistake and you did actually mean to bill both level 3 and 4. Okay, slide 20. So billing together. As I mentioned earlier, you can bill both aspects together or separately. If you do choose to bill them together, One of the most important things here is to make it clear which item of work relates to which aspect. And that's particularly important where aspects have been granted on different dates, so that we can be sure that the work is actually in scope. And also sometimes it can be a bit confusing as to which disbursements relate to which aspect. So they should be labelled on your bill clearly, otherwise we could end up rejecting your claim if it's not really clear. Also, if you did have some items of work where you were dealing with matters at the same time, you should apportion them across the two claims. So something like an attendance with a client where you discuss both matters together, you would need to apportion them across the two. And also, just on billing them together, if both aspects escape the fixed fee, ideally, 2 separate schedules of work should be uploaded for each aspect. It does make it a lot easier and a lot clearer than just doing one schedule for both. Okay, so billing separately. If you do want to bill them separately, that's absolutely fine. To do that, you would need to submit one interim claim for the one aspect and a final bill for the other aspect. One thing to note, and we do see it quite a bit, is that you don't need to submit outcomes for the one aspect prior to submitting an interim bill. So once the interim bill is paid, you can then submit outcomes for both aspects together or followed by your final bill. Okay, moving on to slide 21. So hearings under the Family Advocacy Scheme. So in terms of advocacy under the FAS, if a hearing or hearings included work on 2 different aspects of FAS, so for example, children's and finance on the same certificate, you can't claim the FAS fee for each of those aspects. That's whether they are dealt with at the same time or listed consecutively. And that's because under the terms of FAS, only one standard fee can be claimed per activity. And what we mean by activity is an advocate's meeting or a hearing. So obviously in this case, we're talking about a hearing. You can, however, choose the category to claim under. So you can choose the fee that pays more, basically. And there is a link to the handbook in the slide which covers this. One thing to note, though, is where you have a final hearing that covers both aspects, again, you can choose which aspect to claim under so long as both are covered for final hearing. So, for example, if you have full representation for non-molestation proceedings, but you've only got level 3 cover, so family help hire on the children's matter, you'd only actually be able to claim a final hearing fee for the non-molestation aspect. Okay, so moving on to slide 22. So sometimes you're going to have 2 aspects on a certificate where one aspect falls within the fixed fee scheme, but the other aspect doesn't. So it's an excluded proceeding. So as I think we've mentioned in the slides, you can have non-molestation proceedings, which does fall within the fixed fee scheme, but also TOLATA, which falls within hourly rates. So to make your claims, in this instance, you'd need to submit an interim bill for the one aspect, then send an inquiry to our merits team to change the lead proceedings on the certificate and submit outcomes and a final bill for the second aspect. It doesn't matter which order you submit the claims. As mentioned in the introduction, proceedings excluded from the fixed fee scheme can be found in 5.1 of the electronic handbook. Okay, so another top tip on slide 22. So it's important to remember that if council did any work on the hourly rate aspect, both your claims for that aspect need to be submitted together once the aspect has been made the lead proceedings. Again, you need to submit a merits inquiry for that. Unfortunately, you can't change the lead proceedings yourself at your end of CCMS. For the fixed fee aspect, as always, council need to make all the FAS claims prior to you submitting your final bill.
So slide 24 looks at how to calculate the applicable fee where a provider transfer has taken place. So in this situation, each provider will initially determine their costs at the applicable hourly rate. Half the fixed fee would be claimable where costs are below the applicable fee. The full fixed fee can be claimed where costs are equal to or greater than the fixed fee. And should costs escape the fixed fee, then the claim should be submitted at hourly rates. It's important to note at this point that the cost limit on CCMS defaults to the second provider, with the first provider having just read-only access to the case once it's been transferred, so they can't amend the costs. It's therefore the second provider's job to allocate costs to the first provider on CCMS. Where you are the first provider and your costs have not escaped the fixed fee threshold, you can claim at the end of your involvement in the proceedings. If the solicitor interim option doesn't appear when submitting your claim on CCMS, this is because the second provider has submitted the outcomes and CCMS is now expecting a final bill only. So what you'll need to do is contact the second provider to arrange for them to have the outcomes cleared, after which you can then submit your bill. So looking at slide 25 now, where a provider represents multiple clients and one client moves to a new provider during the case, but the firm continues to represent one or more clients, each provider will claim separately. In the event that a client transferred to a new firm and acts for the client for less than 24 hours, then an hourly rate claim would need to be submitted. However, if they did act for the client for more than 24 hours, then the applicable fixed fee is payable. There are occasions when one firm will not make claim on the fund due to not doing any qualifying work under the standard fee. And in those scenarios, we'd require this to be confirmed within the other firm's bill narrative, and this firm can then claim full payment. And further information on that can be found at 5.25 of the cost assessment guidance. So moving on to slide 26, as already mentioned, the first acting firm could submit an interim bill if they are claiming the fixed fee. Conversely, should the cost of the first acting firm escape the fixed fee too, then they need to confirm with the second firm whether their costs also escape. Where the final firm's costs also escape, then the preferred billing method is for the final firm to submit one claim, including all costs resulting in 1 point of assessment. A point to note here is that these claims are far more likely to exceed the court assessment limit. It is possible, however, for both firms to submit escape claims, one interim and one final, but these must be submitted at the same time, as we do need to consider them both together at the point of assessment. It's important to note that should an interim claim submitted by the first firm is rejected, then the outcomes need to be cleared by the final firm so the interim claim can then be submitted.
So our next topic is supporting documents. And obviously there's a huge variety of different supporting documents when you think of all the different types of disbursements and expertise that you get. And we simply wouldn't have time today to go through all those different scenarios. So the purpose really of this section of today's presentation is to focus on some of the key documents and how they should be presented so that we can avoid rejecting your claims and getting the bills paid as quickly as we possibly can for you. Okay, so slide 28, just some key points generally when submitting your supporting documents. There's no mandatory requirement for how you upload your documents, so they can just be on a single document with everything included, or you can upload each document individually. What I would say, if you do it individually, you might find that very time consuming, and we have mentioned that in our top tip on the slide. So if you do it that way, if you could possibly, and by no means mandatory, it just does make it quicker for us to go through your bills if you can label them. So for example, if you have court orders and you've got a number of them, if you could just type in the date against the heading of court order, we can match them much quicker to your bill. But again, as I said, it probably is quite time consuming doing it that way. What you might find easier and quicker is just to group the documents into categories. So you could have one upload just containing all the disbursements, another document with just your FAS claims, and maybe the bill narrative separately. When you do upload the documents, please can we ask you to make sure they're just in a readable format and preferably searchable. One issue we have come across, and it's quite recent actually, is that if you halfway down a document, when you scan it and upload it, the document will appear our end, sort of where you left it. And sometimes we have our cases where we've been scrolling down the document, and because we don't realise it's not actually at the top of the document, we've missed things and we've rejected them. It's our mistake, obviously, but it is quite easily done. So if you can just check that when you upload the documents, they are at the top of that document. Okay, slide 29. So just a bit about the bill narrative. So for fixed fee bills, this should be really just a brief summary of the proceedings. So it should include what the proceedings are, client name, and their status in the proceedings. So that would be applicant, respondent, or subject children. And it's just basically to make sure that we know that bill narrative is actually matching the certificate that it relates to, because we do sometimes get narratives in and get quite confused and then realise that it doesn't actually relate to that case. You don't have to necessarily put the narrative in a document. You can actually send it as a response to the default document request in CCMS. So particularly where your bill escapes the fixed fee, you can use the narrative as a means to draw our attention to any unusual aspects and or to justify costs that may need a little bit more clarification. So something like travel expenses that don't relate to travel to a hearing. So we just need to know where you were travelling to and its purpose. Okay, when you're submitting final nil bills for associated cases, you can either upload a copy of the bill narrative for the lead case to each associated case, or simply confirm it's the associated case to the lead in the default document request. If you do it that way, if you just also could give us the lead certificate reference so we can link it up. Okay, so slide 30, profit costs. So where the costs escape the fixed fee, we will need the details of all work billed as other. So that's preparation other, attendance on other, etc. Formerly known to anybody who's familiar with paper billing back in the day, they were called dot codes. So file notes will be required for any items that have been claimed at 3 hours or over. And if you are billing a lot of items as draft pleadings, please can you provide details? It's not actually something that we stipulate, it's the preparation of other items and attendance on other, etc. that we stipulate. We do need those details, but what we sometimes find is we get an awful lot of work billed at draft pleadings. So I'm sure you'll understand if we've got like 20 hours worth of work that's just been billed as draft pleadings, we've got a lot of work there that we don't know what it is and it could be out of scope. So, you know, if you're going to use that, we're probably going to ask you for more details. So I would sort of recommend that you actually use the preparation of there. Okay. Slide 31. So if you can ensure your file notes, including notes of any routine work for every item you're claiming for is on your file of papers. Sometimes we'll need to see your files, maybe if there's an issue over scope or something like that. But of course, obviously your files may at time to time be requested for auditing purposes. So you just need to ensure you have all your file notes for every item, and it applies to hourly rates claims, including those that meet the court assessment threshold. Okay, so the information required on CCMS isn't any different from our previous paper billing system, where we the claim is made on a claim 1A form. So we thought it would be useful just to give you a link to this in the slides so you can see what information we're looking for. We can also provide you with a link to another document that you might find helpful. It's on our website under CCMS Supporting Documentation, a guide for providers. And I believe the link will be sent to you in an email after today's event. Okay, so solicitors' FAS, so your claims under the Family Advocacy Scheme, or all hearings claiming under the FAS, you'll need to provide the court order. The information required is covered in our section on solicitors' FAS, so I'm not going to go through that again. Obviously, Simon's done that, but yeah, we do need the court orders for every FAS claim you make. So, slide 33. We're moving on to disbursements now. So the main point here is to ensure any disbursements over £20, including VAT, are evidenced by ways of invoices, disbursement vouchers, or your ledger, and that depends on what type of disbursements they are. Where any disbursements are under £20, we don't need any evidence, but we will still need to know what they relate to just make sure they're actually in scope. So if you're claiming travel costs on a day where there wasn't a hearing, we'd want to know why and where you were travelling to. As you can see in the slide top tips, where you have numerous invoices for the same type of work, so typically interpreters, it really does help if you use the date of work on your bill to match each invoice date of work. It really can get a little bit messy, to be honest, if there's a combination of dates of work and date of invoice, particularly where we may not be able to find one of the invoices. Typically on interpreter bills, they tend to have a lot of the costs are actually the same. It can make it quite difficult to try to determine which actual invoice is missing, if at all. So moving on to slide 34. All disbursement evidence must state the client's name and date of work. At the very least, there must be some reference on there to link it to the certificate, but ideally it should be the client's name. So in the slide 30, we've outlined everything that we would need to see on an invoice, and the top tip on the slide outlined what's required in relation to apportioned costs. Okay, so there are just a couple of disbursements where we do need to see the court order directing the costs. And slide 35 and slide 36 detail our requirements on this. So firstly, we have drug and or alcohol testing. So it's really important that the testing matches the court directions and try and avoid any sort of misunderstanding or confusion. What really does make it a lot quicker for us is if you can highlight the relevant directions in the orders as you're billing your costs and annotate the invoices with the date of the relevant court order. We do see a lot more providers doing this, and it does make an awful lot of difference. It makes it quicker for us and avoids any unnecessary rejects. Because with the best will in the world, particularly if there's a lot of testing, it can get quite messy, to be honest, where you've got different people being tested for different things, different lengths of time, that sort of thing. Another thing is, and it certainly does occur quite a lot, is that the directions can be a bit vague sometimes. They can just be a bit unclear as to what the court actually wants testing. We find this particularly with blood testing for alcohol. So quite often they just say blood testing without specifying what the testing should be. So what we find then is that blood testing is done for everything. It's done for liver function, CDD testing, the hair strand testing, pest testing, and we'd probably just need you to actually justify why it was necessary to do the whole lot of blood testing. So if you do find that they've tested for absolutely everything, then we would need some sort of justification for that. Okay, slide 36. So another disbursement where we require the court order is transcription costs. So there's no codified rate for transcription costs, but we do need to see the court order directing the cost. And where there is no specific order, we would need justification for paying those costs. So, for example, something like an appeal against a final order. And finally, in terms of court orders, where we also need the order is where there's been a specialist risk assessment. So generally, a risk assessment carried out by CAFCASS, or here in Wales, the Welsh Family Proceedings Officer. It's not a recoverable cost, but where it's felt necessary to obtain a specialist risk assessment, such as a sexual risk assessment, if prior authority hasn't already been granted, we would need the orders so we can determine whether the expert service being provided is in fact that of the specialist risk assessment expert, or whether the expert is providing independent social work services. And in the slides, we have links to the guidance on this. It's in the electronic handbook, section 1026, and also in the guidance on the remuneration of expert witnesses, 2018, sections 5.6 to 5.11. And finally, false claims, so under the Family Advocacy Scheme. So Simon covered this in the first part of today's presentation, but just to reiterate, if you could just highlight the relevant information in the court orders, so the hearing times, directions for advocates meetings, bolt-ons and court bundles, this just makes it so much quicker for us to process your claims.
So the final topic for this afternoon is to cover enhancements when cases escape. In the webinar presentation, this does start at slide 38. So as Viv covered the escape thresholds earlier on, I won't go into those again here. So there are two stages to determining the level of enhancement. The first is to determine if enhancement is reasonable to claim in principle, and the second is to determine the amount of enhancement to be allowed and what work that should apply to. So there is overlap between the factors that justify enhancement based on these two stages, which does make it difficult to create an exhaustive list to demonstrate the presence of these factors. So each claim will therefore be considered on its own merits by caseworkers, so it's important to provide as much detail as possible to justify any claim for enhancement. And remember that when claiming enhancement, we're looking for evidence that's more than simply just above the average. It must be exceptional in nature. So when determining whether enhancement is reasonable to claim, there are three criteria to consider. So the first is whether the work was done with exceptional competence, skill, or expertise. So here we'd be looking for evidence that the fee earner has demonstrated unusually detailed knowledge relevant to the case, or skillfully pursued an unusual or difficult legal argument, for example. Also relevant here is, has the fee earner's work on the whole case or specific areas in the case required less time than a less experienced fee earner, or has carried out their work to such a standard that the client has received a better result than might have been expected. And an example of unusual skill may be taking instructions for a client who is a child, seriously mentally ill, or otherwise very vulnerable. We do see evidence for enhancement on claims where providers have highlighted a fee earner's experience. It's worth noting that this isn't sufficient or necessary on its own to justify enhancement as part of this criteria that I've just covered. So the second is whether the work was done with exceptional speed. So has the fee earner carried out a case with unusual speed? Here we'd be looking for evidence that they've carried out a substantial amount of work at short notice, which has meant them not being able to deal with other work that has been scheduled for that day. And the third and final consideration is whether the case involved exceptional circumstances or complexity. So evidence here may include legal issues or challenging witness evidence and taking difficult instructions from the client or other witnesses. Or a case requiring a large amount of out-of-hours work may be considered to fall under this criteria as well. So once you're satisfied on those criteria, you then need to move on to stage 2 to determine the amount of enhancement to be allowed on the work it would apply to. So again, there are 3 criteria that this is measured against. The first being the degree of responsibility accepted by the fee earner. So has the provider conducted work without recourse to counsel? This can include whether in relation to analysis and planning of the case, drafting, or even the advocacy. Plus, has the fee earner identified or addressed evidential issues that might otherwise have meant incurring expert time and fees? So the second criteria here is the care, speed, and economy with which the case was prepared. So where care is concerned, this may include evidence of the fee earner's care in relation to a vulnerable client, for example. For speed, this again is evidence of the fee earner carrying out a case with unusual speed. And in relation to economy, this will be evidence that the fee earner has claimed less time or incurred fewer disbursements than would have been expected. And the final stage here is the novelty, weight, and complexity of the case. So does the evidence provided confirm the case refers to a novel point of law, for example? Weight would mean the volume of documentation or the number of issues arising, or to the importance of the case to the client. And finally, complexity would relate to the same considerations as I've previously mentioned, such as taking difficult instructions or challenging witnesses. If you do want to claim enhancement, a higher amount will be allowed the more of these criteria that you are able to evidence within your claim. So slide 39 confirms the maximum allowable enhancement. So this is 50% in cases concluded before lay bench, circuit judge or district judge, and 100% in front of a High Court judge, Supreme Court, Court of Appeal, and Court of Protection. And finally, on slide 40, this provides some information on the guaranteed enhancement in family cases. So if the fee earner who's conducted work is a member of the Resolution Accredited Specialist Panel or the Law Society Family Law Panel Advanced, a guaranteed minimum enhancement of 15% can be claimed on all work done in any family case. Members of the Law Society's Children Panel can also claim the minimum enhancement, but this can only be applied to work done under the certificate that includes proceedings relating to children. And I just want to mention here that this minimum guaranteed enhancement isn't available for supervision or to work done by other fee earners. So if you are claiming the minimum enhancement, please ensure you include within your narrative the name of the fee earner it relates to and which panel they are a member of. And you can find more information on enhancement at section 3 of the electronic handbook.